And in a few minutes, I am also seeing Katia here. Um, Welcome, Katia. We have several guests, and we have listed Tubi. She is the principal advisor of the Rule of Law Council, and Patricia Perez, and she is part of the Human Rights Inter-American Council, and she's also, we have Mr. Jaguado, he's the coordinator, he's a defensor of the public ministries, and she is the director of judicial independence. So, thank you so much for being with us today. And in terms of this report launch, in terms of the justice operators in the Americas, and in the Americas, we are welcome remarks. Victoria Rivas will give them to us, and Mr. Ambassador Franco. Mr. Director, please come. Thank you, Adriana. Welcome all of you. Good morning, Mr. Ambassador. Welcome. And the whole team that also has for us. It is a pleasure to represent and to present this report in about the independence of justice operators in the Americas. And above all, this has even greater importance because we're doing within the framework of the 53rd ordinary session of the OAE. This report has as its goal present the agenda of the several countries. What are the challenges that the judicial powers face, and if it is true that in this last decade we have made progress quite a bit, we um, there have been some guarantees a disciplinary system that is more efficient. We have prepared, we were given capacitation or training workshops in these countries. We're consolidating the judicial power, independence of the judicial power. Not only we are analyzing the traditional problems and frequent problems, but also on the public agenda, but the new challenges that our countries are facing. But we are also making a contribution that is quite important. We are putting on the table a new roadmap that is a contribution for the countries and to strengthen the internal efforts of our countries that can take us to encounter or challenges, setbacks, or that judicial powers face. The JSCA, we are grateful to you. We are thankful to count on you and and your help because of all these challenges that we are facing. Congratulations to CEJAs and the Foundation for Due Process that is taking place jointly to present this proposal to put forth analysis and to put forth improvements and strengthening of the judicial powers in our countries. Thank you so much. Thank you. Uh,
Gracias, thank you. ¿Me oyen bien?
can you hear me?
Well, good afternoon, everybody. And I'm delighted to be here today at this important and I think timely launch of the Justice Center's new publication on judicial independence. This is a busy week for us with the General Assembly here this week, and there are many issues, challenging issues before us, but I really could not avoid and could not stay away from participating in this event and joining you for, as I said, the launch of this new publication. I'd like to also thank the Justice Studies Center of the Americas and its co-host, the Due Process of Law Foundation for inviting me to serve as your speaker today. I also want to thank the law firm, of course, of Hutton, Andrews, and Kurth for graciously providing this venue for CEJA's first DC-based event since its inception in 1999. Now, as many of you are aware, CEJA was launched in 1999 as a result of the '98 Summit of the Americas initiative. It is now an agency within the OAS infrastructure. Headquartered in Santiago, Chile, the center has spearheaded a number of rule of law and legal reform initiatives in the hemisphere and is recognized, and we certainly recognize CEJA as a leader in rule of law related publications, technical consulting, and training. The United States has been proud to support the center's creation and many of its technical initiatives. A U.S. representative has continuously served on the board of directors over the past 24 years of CEJA. And the current U.S. representative on the board is a friend and colleague, Jenny. Where are you? Yeah, Jenny Mueller-Murphy. Jenny's, as you all know, a staunch supporter of the center and is well known in the rule of law practitioner community. Now, also, as some of you may know, at the second Summit for Democracies, which was held in March of this year, hosted by President Biden, at which participants highlighted that the rule of law is foundational for democracy. At this time in the hemisphere, particularly at this time in the hemisphere, the United States' elevation of rule of law as a central pillar of democracy promotion could not come at a better time. The center's publication, Independence of Justice Operators in the Americas, Regional Situations and Challenges for the Defense of Democracy, addresses clearly how rule of law can be operationalized in justice sector institutions in the region. On the eve of the General Assembly, OAS General Assembly, I would like to share some reflections about the report, as well as the importance of judicial independence in the Americas, which may
La importancia de la independencia judicial, como se dilucidó en la Asamblea General. La publicación presenta una revisión abarcadora completa de la independencia judicial en Latinoamérica, con su duración en la región de la analiza estándares internacionales y información actualizada sobre los riesgos y los efectos sobre la independencia de operadores de justicia en la región, que no incluye solo a jueces, sino también a fiscales y desafíos a la justicia. Una judicatura independiente es una comunidad, un producto muy valioso en cualquier y como representante de la Organización de las Estados Americanos.
Democratic Charter. This is the foundation, in my mind, the foundation, the guidepost really, for democratic governance for all countries in the Americas, including the United States. One key component of the Charter is adherence to the rule of law through the effective balance of power in democratic governance and institutions. It has been over 20 years since OIM member states resolved to work together to put the principles of the Charter, of the Inter-American Democratic Charter, into practice. We have defended independent civil society activists and journalists and watched individuals enjoy equality under the law. Today, however, we find democracy to be in a fragile state across the region. I just came from an event at the Wilson Center on the situation of journalists in Central America. And there were journalists who spoke about not just the intimidation and the coercion, repression, forced exile in Guatemala, El Salvador, and Honduras, but talked about how they had no access to real justice in their countries, and as a result, have had to leave their countries. Democracy, therefore, is unfortunately under attack. In many countries in our region, we now see an erosion of democratic institutions, including judicial institutions. And I am committed to redouble our efforts. You will see this at the General Assembly this week, to the core goals and aspirations of the Charter. Studies such as the one discussed today help guide our work at the OAS in order to find ways to implement measures to stem democratic erosion, democratic backsliding. In the last decade, the region has seen laws enacted to remove safeguards that prevent governments from abusing their power. We have seen private citizens jailed for exercising their rights for free speech, for exercising their right to criticize the government in power. We have seen families, civil society organizations, and individuals attacked because they posed political implements to the power of unchecked government power. The misuse of judicial systems has been apparent, especially in places like Nicaragua, Venezuela, and Cuba, but of course in Central America as well. Loss of trust in judicial systems further erodes citizens' faith in the law and their government and allows for governments to rule outside of the margins of the rule of law. A functioning democracy relies on the balance of independent institutions with checks and balances. And yet, patterns in the region are emerging to weaken judicial independence. This is often a warning sign from anti-democratic governments that plan to further consolidate and make a path for impunity. Further, corruption undermines the core of the administration of justice, generating a substantial obstacle to the right to an impartial trial and severely undermining the population's trust in the judiciary. So, colleagues, the Inter-American Democratic Charter establishes democracy as nothing less than the foundation upon which together we build the future. It is now for all of us, citizens, governments, institutions, academic institutions, together, to put the Charter's empowering provisions to work for the ordinary men and women of the hemisphere. It is for these reasons that more effective use of the Democratic Charter remains a top priority for the United States as we consider democracy and human rights themes at the General Assembly. We are grateful for the novel ideas and brainstorming from many of you, which serve to help advance this initiative. We welcome the strong support that we've received from delegations like Canada, Peru, the Dominican Republic, Panama, and Costa Rica, who have collaborated with the United States in support of new and creative proposals to the Democratic Charter text, which remains open currently and under negotiation at the Assembly. What are our proposals for action? Our proposals include, which I believe are relatively modest but important steps towards strengthening the Charter and strengthening the rule of law and judicial independence in the region. First, it includes a voluntary peer review, early warning, and preventive action, right? To respond to threats to democracy before they become irrelevant. Education for democracy, civic education for democracy, support from the OAS and others to support enhancing values consistent with democratic rule. And as I said, one critical piece is taking diplomatic preventive action and not waiting until democracy is suppressed. These are all fully consistent with the recent OAS mandates from Lima at the last General Assembly. The Inter-American Action Plan on Democratic Governance adopted at the 9th Summit of the Americas and commitments made at the 2nd Summit for Democracy. So in effect, they serve to enable the OAS to engage more responsibly on so many of our shared priorities, especially judicial independence and the rule of law. We hope we can get consensus around this initiative at the General Assembly this week. We will certainly be working hard to achieve that consensus. Let me close by saying that the United States' strong support for the Inter-American Democratic Charter and our ongoing efforts to work with our hemisphere partners underscores the need to leverage the dynamic and vibrant community that exists among regional governments and peoples. We thank the Justice Study Center for this report, which proposes, I think, a new roadmap to strengthen the independence of judicial operators with a focus on the operationalizing of international standards and the generation of preventive, early detection, and protective mechanisms. So I encourage everyone here today to read the study carefully and to find ways for us to work together to take on the challenges in our hemisphere and to follow the events at the General Assembly and to talk to all delegations who will listen about the importance of the proposals strengthening the democratic charter. Again, thanks to the Justice Study Center for inviting me here today. Enjoyed it. Thank you so much.
Muchas gracias por las palabras de nuestra presidenta del Consejo Directivo de CEJA, María Victoria Rivas, del embajador de los Estados Unidos en la OEA, señor Frank Mora. Gracias por sus reflexiones y su introducción. Recordar que estamos transmitiendo vía YouTube por los canales de CEJA y DDPLF a las Américas del mundo el lanzamiento del informe Independencia de Operadoras y Operadores de Justicia en las Américas, Situación Regional y Desafíos de Defensa Democrática, organizado en el marco del 53º periodo ordinario de sesiones de la Asociación de los Estados Unidos.
In the framework of the meeting that is going to take place, the organizers of the
A continuación, tenemos la presentación de nuestra
we will
directora
have
ejecutiva
the presentation of our
convoca Independencia de Operadores y Operadoras de Justicia en las Américas, Situación Regional y Desafíos de Defensa Democrática.
Buenas tardes a todos. Buenas tardes.
Good afternoon to everybody.
En primer lugar, muchas gracias
Thank you so much
a las autoridades por
for the
acompañarnos
authorities
en
for
este
coming
evento.
together into this event.
Agradecimiento al embajador
We
Mora.
are very grateful for Ambassador Mora.
Y le presentamos esta
And we
propuesta
presented
y
this
estaba muy
proposal.
entusiasmado en apoyar
He
la
was
construcción
very
de una mejor
excited
democracia y
about
los derechos de
supporting
las Américas. Igualmente, nuestro
We
agradecimiento
are
a
also
el
thankful
Consejo
to our
Directivo, a las
president,
autoridades allí, donde al final haré todas las respectivas gratuidades correspondientes.
and I will also thank the
En
other
esta
authorities.
oportunidad,
This
quisiéramos
I have this opportunity
comentar
to
que desde el año pasado estamos impulsando un proceso de acercamiento de CEJA y las realidades prioritarias de las instituciones de justicia en países de las Américas.
about the challenges
La
of the judiciaries in the
y
Americas.
estas realidades tan
These
complejas, tan
are very
ricas
complex.
en prácticas, pero también con varios problemas que se presentan a nivel cotidiano.
And
En ese marco, el año
in this
pasado,
framework, last year,
desarrollamos un proceso
we have developed
participativo
a
para
participatory process
desarrollamos un proceso participativo para la construcción del primer plan estratégico a mediano plazo de la
a
institución.
strategic plan.
Y tuvimos la suerte de escuchar a más de 700 personas, principalmente operadoras y operadores de justicia, jueces, fiscales, defensores públicos, entre otros,
Defenders,
a quienes deseábamos
prosecutors,
abrir
between others,
espacios para la construcción de nuestras prioridades temáticas.
to
Es
start
en este
building
marco que uno de
the
los temas
framework
más
of the
importantes
things that we
que
should
se requirió
study.
por parte de las personas a quienes escuchamos fue la atención en la
One
situación
important
crítica y
issue
compleja de la
was
independencia de
the
operadoras y operadores
independence
de justicia.
of the
Y este
justice
estudio
operators in
y este evento
judiciary.
tiene respuesta ya a ese compromiso que nosotros hicimos
Response to
con
that
estas
commitment
700 personas
to
que
these
trabajan día a
700
día
people
en
that
las
work
instituciones de
day
nuestro
in
país
and day out
y que
in our
pidieron que
countries
CEJA tenga una
in
voz
the judiciary, so
institucional al
that we have
respecto.
an institutional voice and be heard.
En este marco, yo quisiera expresar también nuestra especial gratitud a Mauricio Duce, un viejo consultor experto de nuestra organización, quien no dudó en tomar este encargo y preparó un primer documento sobre el cual se ha presentado en su trabajo institucional.
in which this work was based.
La
Institutional
independencia
based,
la independencia judicial, específicamente la independencia desde una perspectiva amplia y crítica, no es un tema nuevo para CEJA. El primer conjunto de publicaciones que hizo la organización, las reflexiones en esta materia datan del año 2002, cuando de diferentes estudios se planteó una visión innovadora de la problemática, cuestionando que el foco sea solo puesto en la relación entre poderes judiciales y poderes ejecutivos, y más bien proponiendo una mirada mucho más operativa, una mirada que atraviese lo institucional, dado que también hay afectaciones en el interno de las instituciones. La reflexión de CEJA desde sus inicios siempre ha sido mirar más allá de la relación entre lo que es independencia externa y más bien poner foco en una perspectiva más dinámica en términos de procesos internos que también se presentan dentro de las instituciones. Por lo tanto, hoy día, con este estudio, también nos hacemos cargo de este planteamiento, de este enfoque que es lamentablemente validado y incrementado a raíz de las prácticas que hemos levantado para hacer este trabajo. Como ya se ha mencionado, hemos querido que a través de este estudio se planteen unas perspectivas regionales panorámicas de lo que viene sucediendo y a la vez también presentamos una hoja de ruta que ponemos a consideración de los estados, de las instituciones de justicia, de las agencias de cooperación, para poder contrastar estos hallazgos. La parte del desarrollo voy a ser muy concreta, el estudio es bastante profundo, profundiza los estándares internacionales, profundiza en varios estudios que de diferentes organismos, siguiendo de la sociedad civil, se han desarrollado y levanta atrás mucha evidencia confiable detrás. Obviamente, por razones de tiempo, yo no voy a profundizar, pero a través de esta presentación he querido referirme a los temas más puntuales. Primero vamos a presentar de manera muy concreta los objetivos y las preguntas clave de este estudio, cuáles son los alcances y las limitaciones del mismo, cuáles son los principales hallazgos a manera de conclusiones centrales, y cuál es concretamente la propuesta de nueva hoja de ruta que CEJA propone para enfrentar los retos. Como ya hemos mencionado, el objetivo central del estudio ha sido una revisión panorámica de la situación de jueces, pero también de fiscales y defensores públicos de las Américas. Creo que ahí es el valor que hemos querido desarrollar a través de este primer ejercicio, que plantea una preocupación no solo bajo la óptica tradicional de lo que es independencia judicial, nos referimos a la relación entre los poderes judiciales y ejecutivos, sino también abre de una manera ya más concreta y desde una perspectiva regional la situación de los fiscales y también de los defensores públicos que tienen otra naturaleza en su labor, pero que también, como se ve en el estudio, presentan ciertos riesgos. Las preguntas de partida para iniciar este trabajo, cuando nos propusimos a finales del año pasado, fueron dos muy concretas. ¿Cuál es el estado de la independencia de los operadores de justicia? ¿Cuáles son las diferentes manifestaciones de las afectaciones de riesgos que hoy en día se dan? En cuanto a los alcances y limitaciones, podemos mencionar que se trata de un estudio regional, panorámico. Como ya hemos mencionado también, implementa un enfoque amplio e inclusivo de lo que es la independencia de operadoras y operadores de justicia. Sistematiza prácticas identificadas a través de fuentes secundarias, principalmente organizaciones internacionales, sociedad civil, una documentación, sobre todo a nivel de cada país, con fuentes secundarias confiables. En términos de limitaciones, obviamente requiere una profundización a nivel de cada país. Es lo que queda como la siguiente parte de lo que tendría que venir. Vayamos directamente a los principales hallazgos. Nosotros identificamos, y primero lo voy a mencionar,
I wanted to mention first, and I wanted to say 5 main findings. So when you see the study, it will be available in Spanish and in English and Portuguese. It has a lot of information that we have gathered, but that has been analyzed. and it's been independently from JSCA. It's been hard to systematize these findings, but it's been this is the findings that we've reached. The first finding is that based on the evidence, there is a serious regional deterioration of democracy, and with the rule of law included, and the independence of justice operators. And we will go deeper on the relationship and rule of law and independence of judiciary. Number two, there are risks and effects quite visible as well as subtle effects. But there are things that are under the surface. And there it has to do with judges, but it also has to do with prosecutors. We're focusing on prosecutors. The third finding is there is a fluid and connected relationship between the different affectations and risks, which exceed the existing conceptual categorizations, and we can go beyond of what is already existing in terms of international findings. The fourth finding is the international standards must be operationalized with a perspective of implementation, as the ambassador said. And the fifth finding, since we're talking about systematizing everything we have worked, is the professional career path of justice operators presents special areas of risk and required care. In terms of the first finding, we want to mention a significant part, one significant part of the problem that we have documented in this regional report has to do with complex problems in the quality of democracies and the rule of law in the region. In other words, there is a direct relationship between the decline of democracy and the rule of law and the decline of the progress of the independence of the judicial systems. It's not only on the qualitative level, but also on the quantitative level. We have analyzed a lot of data on these reports. We have a table and so we have the democracy index on civil liberties for Argentina, and also the global state of democracy in the independent judiciary. So with tons of data, we have found the following information. According to the first index on democracy, the democracy index on the civil liberties in America Latina, since 2020, Latin America had a development of civil liberties that was around 6.79, and up to the year 2022 it has declined to 6.61. We have to recognize that at a global level, this index for the decline of civil liberties in the world is 5.43. In terms of the global state of democracy, it has an assessment criteria. We have to take into account that not all the indexes have an index of judicial independence, but in terms of South America, we have to present both indexes differently, both for South America and Central America. At this moment, from 1992, we have been gathering up to 2017, but concretely in 2022, in terms of independence, according to this instrument, we find ourselves in the same point.
Recuerdo
But
este
Central Americans'
instrumento, mira, uno de los
situation
primeros
is even worse.
identificador de
While in
desigualdad social de
1975, the
Bushwick
Independence Index
estaba en cero coma
that has to do
ochenta y
with merit
nueve. En el
criterion was
2017
in
mejora, cero coma cuarenta y nueve, y
0.43,
en el
and
2021
then in
estamos en
2021
0,40. O sea,
has
estamos
gone down
más
to
bajo que en
0.40.
1975. Y esto nos
So
motiva una
it's
reflexión
gone
en
down
torno a
since
lo que ha representado
1975.
o no
And
las transiciones democráticas
this
que
has to
había
do with the
en
democratic
particularmente
transitions that
a
Latin
finales
America
del
has
siglo
gone through, especially Central America towards the end of the last
Bien,
century.
presenta o
Um,
desarrollo de criterios más
so
específicos sobre
the one
independencia
that
judicial,
presents the
plantea al
more
menos dos
critical
ámbitos en el
criteria, at
ámbito de
least on two
justicia,
levels, on
justicia
the
penal,
level of
es el índice
civil
de Rule of Law
justice
del
and
año
criminal
2022, que
justice.
lo presentamos
We
aquí.
go
Tiene un dato global,
from
un dato estatal y un dato
2022. It has
internacional.
there's an index for global
En términos
justice, and then
estos
in
precios,
criminal
proyectos
law, and then
único que desarrolla
justice,
estos temas
civil
que se
law,
requiere que haya más
and it
índices que trabajen
requires
estos.
other indices that
Y bueno,
work
los
with this
datos que
data.
ustedes ven allí nos
The data
presentan
that you
varias
are
reflexiones
looking at now,
que
it
tampoco voy a, por
represents,
restricciones de tiempo, profundizar, solo mencionar
because of lack of
muy
time,
pocos
I will
datos,
only
por
mention two
ejemplo,
few countries.
Brasil,
For
como
example,
cabeza,
Brazil, Costa
tiene los datos de
Rica
independencia
have the
eh,
independence,
mejores
judicial
que sus
independence
datos
data.
globales
They
de
have
democracia.
better
O sea, en
indexes
pocas
than the
palabras,
global
la mayoría de países
independence,
como
judicial
excepción de
independence
estos países
indexes. Most
tienen sus
countries, with the
indicadores
exception of
globales
these
de
couple of
democracia
countries,
mejores
have
que los de independencia.
global indexes
Y
that
obviamente las
are
brechas entre los
better
datos de algunos
than
países es más drástica
their
que otros.
judicial independence indexes.
Como ustedes pueden ver, de acuerdo
As
a los
you
datos,
can
hay
see,
situaciones de
according to this
países
data,
muy
there are
complejas, donde las brechas entre la data recogida es muy delicada. Y hay países donde
breadth among or
también
differences among
necesitarían un
countries that are
progreso
too
más notorio y
big,
existen
and
retos. Un hallazgo
there
importante
are
en materia de
some
protección
challenges that
es que
continue to
dentro
exist in these
de los
indexes, that
países los
within
datos también
these
varían de
countries, these
acuerdo
the
a
data also
justicia penal.
varies
Menciona también que la
according
necesidad de
to
una
criminal law or
política que
civil
ha
law, and this
planteado a través
is
de
what JSCA is presenting in this study.
Hay muchos más datos que se van a encontrar en
There
el
are
reporte,
many
sin
more
embargo,
studies that you will
quiero
find in
hablarles
this
sobre
report, but this is what we wanted to present to you, this numerical data. In terms of the next finding, in affectations and highly visible as well as acute risk, we have evidence systematized in the study shows a wide diversity of affectations and risks. Some of them are visible, notorious, and open, and some of them are open to world scrutiny, but then in some other instances it's not as great. But there are many risks at an operational level. But if we talk about for strengthening the democracy, it is important to care and to stop the bad practices identified lead to forecasting the possible aggravation of the effects on the independence of justice operators and their impact on the weakening of rule of law and democracy. We would have liked for these numerical data and quantitative and qualitative took us to a different conclusion, but this is the work that JSCA has done, and they have done this objectively, and this is the conclusion. And on this point, the evidence shows a worrisome situation regarding the independence of prosecutors, not just of the public ministries or institutional ministries, but also the prosecution. The next finding, there is a fluid and connected relationship between the different affectations and risks which exceed the existing conceptual categorizations. Part of the study develops and analyzes different concepts that have been put forth at different times about what it is in judicial independence, internal independence, external independence. There are theories that are geared toward dealing with these topics. But notwithstanding, we conclude that these ideologies have to do more with stagnation than the effects and risks that have to do with daily practices. And that's one of the things that we consider within JSCA. So, and Mr. Ambassador also touched on this. And so it is necessary to deepen the situation of the operators and that justice operators have, and not only pay attention to the institutional independence. So let's make a stop here in terms of reinforcing what we've mentioned about putting aside what the traditional concept of judicial independence is, or the relationship among powers, and to look deeper to what is happening in terms of the relationship among the different powers. And this is the second to last finding. International standards must be operationalized with a perspective of implementation. The existing international standards, not only in the US, but those who are on the global stage, they are accomplishing their goals, and these are the first principles. But they don't, they don't, they must have the operational knowledge or know-how to implement it, but we have the space of opportunity and necessity to be more specific and precise, um, so that so so that it limits the bad practices, so that the best practice can be put in place and implemented, and that there can be monitoring, technical monitoring. And this should be validated with the work that we have on a daily basis with the justice operators. That it's our focus. And in terms of the standards, we need to conclude that these standards have been designed with a logic of judicial independence. We've been thinking, obviously, about the judges and these institutions of judicial powers, and the place they have in the Americas and the role they fulfill in terms of rule of law and democracy. And this report concludes that the prosecutors need um, a specific regulation in terms of human rights treaties, and they also need to develop specific standards. And there's been an advance. So the commissions and forums, the Inter-American forums, and the tribunal, the Justice Tribunal, and the Association of Public Defenders, they have gone a long way in terms of promoting and developing standards. But we need a more specific content, considering that the function of prosecutors has to do with reform and due process has to do with more than 20 countries in the Americas. It requires a special treatment for this work and the role that they play, that they have in this.
And the last
Integrar el
idea
estudio, porque
was,
estoy segura que ustedes van a encontrar sus propios
I'm
hallazgos
sure that
en los países.
will
Es
get
que
up
la
some
línea de
findings,
carrera
but
profesional, en términos más institucionales y
institutional
operativos,
in terms of
representa espacios de riesgo y por tanto de cuidado en materia de prevenir concentración, detectar oportunamente y evitar las afectaciones. Identificamos muchas formas en las cuales
high risk areas. We have
la
identified
legislación,
several of them in the selection, designation, ratification, removal, and disciplinary process of judges and prosecutors. And I will refer to cases that have been more documented and more serious. Some cases have not been have not had enough attention, but for us it's very important to highlight them because there is a relationship between the political and the rest and the judiciary, and also the internal processes.
La no aplicación de sistemas
The non-application of the design legal system changes in the powers and functions of the body in charge of sector, and the incorporation of members with a political affiliation are some examples of the effects that we have identified. in
Y
this
para
study.
finalizar con
And
una
to the
perspectiva positiva y
we have
proactiva, que es
a
también una
positive perspective and
caracteriza a
hopeful one,
CEJA, como ya nos mencionó la presidenta de nuestro
as
consejo
mentioned
directivo.
by
CEJA
our
propone una
president,
ruta global
is proposing
para
a
la
new
supervisión de
roadmap
independencia operadoras y operadoras
to
de justicia nacional. En concreto,
strengthen
propone
the
seis
independence
puntos de
of the
trabajo.
justice operators.
Una agenda de investigación.
Research agenda.
Nosotros somos un centro de estudios,
We
un
are a
centro
center of
técnico,
study
siempre vamos a
and a
proponer
technical
estudios relevantes en práctica. Una agenda que
organization.
profundice en
We
estos
need
mismos
an agenda
investigaciones
to
y que también clarifique ciertos
to clarify
conceptos
certain
y
concepts
en otros casos los construya,
and build
pero motive
others,
contenidos pertinentes para
proposing
seguir
contents
avanzando en
to
mecanismos
continue advancing to
como ya hemos mencionado,
independence.
y como mencionó
As
también
it's been
como
said,
señaló el señor embajador, la
and
construcción en
the ambassador
materia
said as well,
de
the
estándares
building
y
standards
implementación es fundamental y
and
tampoco dentro de
implement
esto
and how to implement those standards
y de defensores
very
públicos que
important.
nos queda pendiente desarrollar, pero sí se
We-
plantea en el informe en términos también de la función que
In
ellos
the
cumplen
report, we also touch on the
contracorriente en el ejercicio del
public
debido proceso
defenders,
que
but we do
mencionamos
delve
ahora.
into the judges and
El
the
segundo
prosecutors.
elemento de nuestra
The
hoja de
second
ruta
element of the roadmap
plantea el acompañamiento, la promoción, la implementación de políticas institucionales para incrementar la confianza y la legitimidad de las instituciones de justicia. Y
to
sí,
make
hacernos
our
cargo de la legitimidad institucional en términos de
institutions
que a nivel
more
institucional
reliable in the face of the public. That
construir
it is very
mecanismos
important to build mechanisms
ese deterioro,
to
esa erosión,
to
como dice el
prevent that
señor embajador.
deterioration of the
Índices
erosion
como
that the ambassador
índices de
referred
las
to.
personas, tipo
For
centralidad, que hoy en día se viene promoviendo, lo que pueden resultar son muy útiles para esta nueva repensada de lo que es la gobernanza judicial,
To
la
think
calidad de
about
servicio.
how do we do the
Otros
governance,
principios
how
como
we
justicia
provide the
abierta,
services, another one is
transparencia,
the
la
transparency.
veeduría ciudadana, es decir, en espacios
What
actuales
I mean
de
is that in the actual
polarización
cases, there is so much polarization in Latin America. It's very
seguir
important
apuntando a la construcción y al diálogo y a los mecanismos
to strengthen
innovadores
the
que
dialogue
nos permitan hacer que los sistemas de
new
justicia estén
new systems
rediseñándose
that
de cara a las
our
necesidades ciudadanas y
judiciary
dentro de esto de contar como operadores de justicia que se sientan respaldados,
designed with
protegidos por sus instituciones.
a way in which our
Mejoramiento de los
justice
diseños
operators
técnicos y la supervisión de los
strengthen
sistemas
and
asociados
protected
a
by
la
the
línea de
system,
carrera.
by the
Aquí hay
government.
todo un ámbito técnico. de
There
los
is
procesos
another
de
point,
de
which is to protect
los procesos de
the
remoción, de disciplina,
processes of
de
discipline,
ascenso, todo este
of
ámbito técnico
remotion
que
and
deja,
dismissal
lo
and
desarrolla,
appointment,
estudia y propone
and
un
the
ámbito de
document
mucha
has proposals
oportunidad para
with
prevenir,
a lot of
detectar
opportunity
y
to prevent
evitar
this kind of
el mal uso y también apuntarse a la
the
institucionalidad.
misuse of these.
Como cuarto elemento de
These,
nuestra hoja de
areas.
ruta fiscal, proponemos
fourth
el
one
incremento de las capacidades
Increasing in the
actividades y
attitudinal
habilidades de los
capacities and
operadores y
skills of
operadoras.
justice operators.
Esto me pareció muy importante
To me, it was very
plantearlo en
important
términos de que
included because
ya se ve un empoderamiento de
there
los
is an
operadores.
empowerment
En
of
varios
the
países de
of
nivel,
justice operators in
tenemos
many
ahora
in many
representaciones de
countries.
las asociaciones
We
federativas
have a participation
gremiales
of
de
the
jueces y
field
fiscales. Entonces, aquí hay
of,
una necesidad de seguir
of judges
empoderando
and prosecutors, but there is a need to empower
iniciativas de jueces de fiscales que
of
buscan
judges and prosecutors
construir más contenido de cara a esta independencia, ¿no? En
look
términos
to
de
have more
jurisprudencia, en
independence
términos de sus prácticas, en términos de ya sus propios procesos,
in the terms of
incluso en el
taking care of the
ámbito
processes
psicológico, el
and
estudio también toca este tema,
in the
perfil
perspective,
psicológico de las
in the
personas que
psychological
trabajan en
perspective,
esas funciones,
the
de cara
study
a poder
touches
desempeñar
on
un
it so
rol
they can
constitucionalmente adecuado y
play
cómo
the role in an adequate way, but also it touches on leadership
tan compleja como son las
in
estructuras
this structure that is so complex.
Entonces,
That
ahí me
in
parece
these
que
kinds of
aportamos
very important. So we also provide a perspective
y una mirada
in
actitudinal
of operation
empoderamiento de estas
and the empowerment of these
como quinto
individuals. The
elemento de
fifth
nuestra
element
propuesta,
of our proposal,
sugerimos el
we
diseño de
suggest
estrategias para
the design of
contrarrestar la
strategies to
corrupción.
counteract
Y
corruption.
esto agradecemos que el señor
And we are
embajador
grateful
Mora se
for
haya
the
encargado de una
Ambassador
manera
Mora
explícita, nos
as being in
permite
charge of
avanzar en
that.
esta línea.
and we have been able to advance
El
in
estudio no está focalizado en la
in this
corrupción,
point.
pero obviamente
The
plantea
study
también
is not focusing on corruption,
obvia la relación entre a
but
mayor
it is
problemas de
obvious that
independencia,
the
mayores
relationship,
riesgos
because
de manejo no solo
the
político,
worse
sino
the worse the state
de
of
corrupción de las
independence,
redes de corrupción
it is also
pueden
because
afectar
of
nuestras
the
instituciones.
networks of
Nosotros
corruption that can
cuando hablamos de
affect the
independencia, no
institutions.
solo hablamos
So when
de autonomías,
we are
¿no?
not
sino
talking
también de
only
responsabilidades
when we talk about
internas para
independence, not
prevenir,
only
detectar
autonomy,
y sancionar la
but
corrupción que
prevent
afecta a las instituciones de justicia.
corruption that
Y
affects
principalmente no solo la
the judiciary.
corrupción son fundamental atacarlas, sino también la corrupción del día a día que
It's
afecta
not
a las
only the
personas
big,
vulnerables.
what
Y
we
reiteramos
think
tipos de
of the whole corruption, but the things that happen day in and day out. That,
también de los territorios, incluyendo los territorios rurales, los territorios
and
en pobreza que
it
caracterizan a
includes
nuestro
the
país.
areas, the rural
Y
areas.
finalmente, como sexto elemento de nuestra
Of
propuesta,
our proposal,
sugerimos
we
y nos
suggest,
ponemos a disposición
and
para desarrollar planes de capacitaciones
we would like
regionales
to help.
como una estrategia
We are
transversal para
hoping to
mejorar la
train,
independencia judicial,
to do some training,
identificando y diseminando las buenas
identifying and disseminating good practices,
y las lecciones aprendidas que
take a
tenemos
look at the
para
lessons learned,
mostrar en nuestros países y en nuestro trabajo de nuestros
so
operadoras y operadores y de nuestras
so we can
instituciones
benefit
en esta
our
materia.
work and
Con
the
esto
independence
termino
of
la presentación. Muchas gracias por
the
su atención.
operators of justice in Latin America. This is the end of my
Muchas gracias,
presentation.
Natalie, nuestra directora ejecutiva de CEJA,
Thank you,
con la
Megan,
presentación
our
de la
executive director
publicación.
of
A
CEJA.
continuación
We
tenemos
will
la
begin.
presentación de
We
Lisette
will
Luis,
follow with the
asesora
presentation of
principal del
Mrs.
Estado de
Lee.
Derecho de Seguridad Ciudadana en USAID.
She works
Nos va a
for
hablar acerca de la
USAID
independencia judicial desde una perspectiva de justicia centrada en las personas.
and she has had remarks on the
Por
report
favor,
of
se va a
independent
conectar vía
justice.
virtual. Usted tiene la palabra.
They said you have you
Muchas
go
gracias.
ahead.
Primero
Thank you so much. First of all, I want to say
todavía congestionada
I'm very sorry because I am recovering from
puedo toser.
feel congested.
Buenas tardes a todos. Yo
I
estoy
do.
muy agradecida de participar en esta
I am
oportunidad
very
y
grateful to
esta actividad
participate
con
in
todos ustedes.
event.
Muchas gracias por invitarme al
Thank
CEJA,
you
con quien USAID
for
tiene una
inviting
relación
for the
estrecha
invitation.
desde su establecimiento
We
y
have
donde he tenido el privilegio de estar en visitas ya hace algunos años.
privilege
Y hay que corregir esto y
for
volver
some
a
of the
verlo
events.
definitivamente. Excelente presentación, Natalie, de este
Natalie,
estudio.
your
Es un gran
presentation
aporte para todos los que trabajamos estos
Ah,
temas en esta región.
that
Y
great
como ella dijo, hay un gran
that
debate sobre la independencia de los actores de
really
justicia.
issue.
Por lo tanto, el tema que les traigo hoy es relevante.
Is,
Y aunque no es
impact
una
of the
panacea a todos los problemas, esperamos que sea parte de las soluciones y
we
mejores
hope
prácticas
that this study
que
will be
hemos visto para enfrentar este problema precisamente por el tema de confianza y legitimidad.
it is very
Mi
important
intervención hoy tratará
the
sobre la interacción entre la independencia judicial y la
legit
justicia centrada en las personas, o sea, people-centered justice, como pieza central de la
we
nueva
are going to
política
talk
del
about
Estado de
people
Derecho,
centered
emitida
justice.
por USAID en el pasado mes de mayo. Perdón. Y
Yes,
esto implica, como dijo el embajador,
Right, as the ambassador mentioned, just a second.
y esto implica, como dijo el embajador Frank Mora, elevar este tema por parte del gobierno de los Estados Unidos, lo cual es un gran apoyo.
We have a
Ya
support of
entrando
the
en
government
materia,
in the United States.
la relación entre la independencia judicial y la justicia centrada en las personas es un aspecto
The justice
fundamental
and the
para un
justice of the
sistema legal justo y efectivo.
basic
La
for
independencia judicial se refiere a la
in
autonomía
education
del poder judicial
the
frente a
autonomy
influencias
of
y
the
presiones
judicial
externas,
from
lo
other
cual permite a los jueces tomar decisiones
which allow
judiciales y
judges to
certeras.
make decisions.
Pero también hemos visto en algunos
Under the
países
pressure,
de
but
la
we have seen,
región, incluyendo República Dominicana, una
for example, in the
influencias y
Republic,
presiones internas
of
dentro del
pressures,
mismo poder
internal
judicial.
pressures in the
Por lo tanto, la justicia
judiciary.
centrada en las personas enfatiza
Justice
un enfoque
centered
en los
people
individuos y
puts
sus
a focus in
necesidades
the
dentro del
individuals
proceso
and their needs in the
legal,
legal process,
garantizando un acceso
warranting
igualitario, equidad y
plus
capacidad de
equity
respuesta.
and
Quiero resaltar
response
por eso
and
cómo
capability of
esta
response. I
conexión
want to
entre
stress that
independencia
the
judicial y esta justicia centrada en las
interconnectivity between
personas y ver cómo estos dos
the judicial
conceptos se
system
refuerzan
and
y
the people.
apoyan
Both
mutuamente
of those
en el
concepts
fomento de un sistema legal justo e inclusivo. La
affect
independencia judicial, como aquí se ha
the
mencionado,
the
es
judicial
la piedra
independence.
angular
It's
de una
being
sociedad
said it's
democrática
a
y
cornerstone of
desempeña un papel fundamental
and
en el
plays
mantenimiento del
a
Estado de
very
Derecho.
important, a fundamental
Donde los jueces
for
están libres de influencias
in
indebidas,
the rule of law.
pueden tomar decisiones basadas en
When they
principios
are
legales,
independent, judges
pruebas
can
y disposiciones
rule
constitucionales,
in
en
the
lugar
way
de
that are
sucumbir a cualquier
constitutional
tipo de
instead
presión.
of
Esta
uh,
autonomía
any
les
pressure.
permite actuar
It
como árbitros
allows
imparciales,
the need to be
garantizando
impartial
un trato justo
and
y una
warranting
protección
uh,
igualitaria de todas las personas,
equal protection for
independientemente
all
de su
people,
condición, que acuden a los tribunales.
notwithstanding
La
what their condition.
independencia judicial,
The
hemos
judicial
visto que
independence
protege contra el riesgo de la corrupción también,
also
interferencia
protects from the
política,
risk of corruption,
erosión de
the
los derechos
interest, the
fundamentales
political
y la
interference,
democracia,
and it protects
fomentando en última
democracy
instancia
and
la
the
confianza
basic
pública
human
en el
rights.
sistema de
It
justicia.
also propagates
Entonces,
the
¿cuál
of,
es la
of
esencia de la justicia
just
centrada en las personas, de People-Centered
of
Justice?
the judicial
La
system.
justicia centrada en las
The,
personas sitúa a
the
los
justice focused
individuos
in
en
people,
el centro del proceso
puts
legal,
individuals in the center
reconociendo
of the legal
primero
process,
sus diversas
recognizing
necesidades,
their
sus
needs,
experiencias y sus
their experiences, and their
vulnerabilidades.
vulnerabilities.
Busca garantizar que la
It
justicia
looks,
sea
it seeks
asequible,
that the justice is
accesible y
accessible,
comprensible para todos,
comprehensible
independientemente,
for
como hablamos
everybody,
antes, de su
independently
condición
of
socioeconómica,
their
antecedentes, etc.
conditions and their economic
La
situation,
justicia centrada en las personas implica
and it
proporcionar una
might
asistencia
also
legal
provide
adecuada, apoyar los mecanismos
adequate
alternativos de resolución de
and,
conflictos,
and,
promover enfoques de justicia
promote
restaurativa
focus
y
of
emplear procedimientos
restorative justice
amigables
and
para el usuario. Al
processes
colocar las
that
necesidades
are
y preocupaciones de las personas
understandable.
en primer plano, en vez de la burocracia,
Putting,
los
putting people first
procesos,
instead of the
las
processes of
instituciones,
bureaucracy,
la justicia
institutions,
centrada
the
en las
just
personas
center in
mejora el acceso a la justicia, empodera a
the
comunidades
justice,
marginadas que de otra
empowers
forma serían
vulnerable,
excluidas
marginalized
y
communities,
construye confianza
and
en el
trust
sistema
in the
legal.
system, in the legal system.
¿Cuál es entonces esta sinergia,
Which
esta conexión entre la independencia judicial y
is
la
the
justicia
connection
centrada en las personas? Bueno, es
between the
simbiótica,
independence
ya que cada
and
concepto
justice.
refuerza y fortalece al otro. La independencia judicial es esencial para mantener la integridad y credibilidad de la justicia centrada en las
Integrity and credibility for
cuando los jueces
people-centered
están
justice
libres de
when
influencias
judges are
o
free from
ideológicas,
influences,
pueden mantener
external
una
or
posición
external or internal.
imparcial
They
y
can
garantizar la
process
protección de
cases
los derechos de
without
las
bias
personas.
and
Además, una
guarantee
justicia
the
judicial
civil
independiente,
protections
como
of the
sabemos,
people.
actúa
In fact, an
perdón,
independent
como un
judiciary
control ante
serves as
posibles
a
abusos de poder
control
y
against
asegura que
abuses
la
of power,
justicia
potential
sirva de manera justa
abuses of
y
power, and
equitativa.
guarantees that justice is
Por
served
otro lado,
in an
entonces,
equal fashion.
la justicia centrada en las personas contribuye a
But
la preservación de
on
libertades
another
y
hand, on the other hand,
al priorizar
people-centered
las
justice
necesidades de
also
las
guarantees
personas,
that the process,
fomenta
the
la
judicial
confianza
process, is
pública en el
focused on
poder
people,
judicial.
and it
Cuando las
fosters the
personas perciben el
public
sistema
trust on the
legal como
system and the
justo,
justice. When people
accesible,
consider that the
receptivo a sus
judicial system
preocupaciones,
is
es más
fair,
probable
accessible,
que
and
las
attentive to their
decisiones de
needs,
los tribunales
it is more
desempeñen un
probably that they
ejercicio
will
de justicia.
cooperate and they
La
will
justicia
see
centrada en las personas
as
también
something
ayuda
valuable. But
a
people-centered
identificar
justice
algo muy
also
importante,
helps
que son los problemas sistémicos
to
y las
correct
brechas
something
en el
that is really
sistema
important,
legal,
and it is
destacando
systemic
la
problems
importancia
and
de
gaps in
mantener
the
un
judicial
poder
system,
judicial
and that
independiente
way
que
we
pueda
maintain an
abordar
independent
estas
judicial system that
preocupaciones
can deal
sin
with
sesgos.
those with these
Conclusión en torno a
concerns
una
without bias.
relación que es
In terms of this
esencial para el
relationship that is
funcionamiento de un sistema
crucial
legal justo
for
e incluyente.
the
La
for the
independencia
creation of a
judicial
just and
garantiza la
inclusive
toma de decisiones
judicial system.
imparciales
So
y el
independence
mantenimiento del
guarantees
Estado
the
de Derecho y
decision-making
protección de los
process and
derechos
the rule of
externos.
law and the
Y la
protection of
justicia centrada en las
from
personas
external
permite
influence.
satisfacer
And
las
people-centered
necesidades
justice
de
also
los individuos,
satisfies the needs of
mejorar
individuals. It
fortalecer
improves the
su
access
nivel de
to
confianza en
justice,
el sistema
and
judicial.
also it improves
Ambos
the
aspectos,
trust on the
ambos aspectos de
judicial
seguridad
system, while
deben quedar
it provides both things. With
garantizas.
when the
Los
society
sistemas
provides a
de
legal framework
justicia
that
activa y
provides
receptiva para
equal and
todas las
just
personas,
and receptive
especialmente aquellas que son más
justice
vulnerables.
system for
Ahora
everybody,
hablaré un
especially
poco
those who are
sobre
more
nuestra
vulnerable.
experiencia en la República
I will talk a
Dominicana.
little bit about our experience in the Dominican
En
Republic.
nuestro caso,
In our
la voy a
case,
titular Mejorar
I will
acceso,
title this
equidad y
Improving
capacidad de
Access,
justicia.
Equity, and
En los últimos años, la
the
República
capacity
Dominicana ha
to
avanzado
answer.
significativamente en la
In
promoción
the
de la
last few
justicia
years, Dominican
centrada en
Republic
las
has
personas.
progress
Quise
in the
el
promotion of
establecimiento
justice,
de
people-centered
esfuerzos
justice, and it
concretos
continues to
para
strengthen
mejorar ese
efforts
acceso,
to
esa
improve
equidad
this
y
access
esa
and the
capacidad
equity and
de
capacity
respuesta. ¿Cómo lo hemos hecho?
to
Bueno,
answer.
algunos
How have we
ejemplos
done
son el
this? Well, some
establecimiento
measures
de
and some
centros de
examples is
información
we have established
para los
the
usuarios,
Justice
tribunales
Center for
móviles que han
users
tomado
for
la iniciativa de extender
mobile
servicios legales
courts and
áreas
uh,
desatendidas,
justice
incluyendo
centers, local
comunidades
justice
rurales
centers
y remotas.
that address
Estas
the need
iniciativas tienen como
of the
objetivo
rural
cerrar
communities.
brechas
These
de salud
initiatives
mental en las
have
poblaciones
as its goal to
marginadas,
close the gap
brindando asistencia
within the
legal,
system
información
and
ética y asegurar
just
los derechos
communities
de los
that are
ciudadanos,
far to reach.
independientemente de su condición económica o
Independently
social,
of economic
teniendo el
status
mismo
or
acceso a la
uh,
justicia.
so that they
También
have the
se han
same
realizado
access to
esfuerzos
justice.
para
Also, we
fortalecer la
have
equidad y garantías
made
procesales
efforts
en
to
el sistema de
guarantee
justicia.
the
Por
equity
ejemplo,
and the
la implementación de
prosecution
mecanismos
guarantees in
alternativos de
the
resolución de
justice, for
conflictos
example,
como mediación
implementing
y
mechanisms for conflict
conciliación.
resolution,
Brindan a los
conciliation,
ciudadanos la
mediation.
oportunidad no
These
solamente de
gives people
resolver
the opportunity
sus
not only to
conflictos
solve
fuera
conflict
del proceso formal y
outside the
jurisdiccional,
formal
sino que
process of the
fomenta
courts,
soluciones
but it
amigables
also
en todos
fosters
los casos, claro,
amicable
y
solutions,
reduce la carga
not in
del
all cases,
sistema
obviously,
judicial.
but it
Además,
lessens
las
the burden
iniciativas para
on the judicial
enfrentar
system
los
as it is.
retos judiciales
Also,
aumentan la transparencia
we
y mejorar la
make
capacitación y
increase in
profesionales
transparency,
dentro de todos los
promoting
procesos que
the
contribuyen a
training of
brindar una
judges and
sana decisiones
professionals. It contributes
justas
to
e
a
imparciales.
decision-making process that is
Por otro
just
lado,
and
también
unbiased.
se ha
On the
demostrado
other
un
hand,
compromiso con la
we
protección de
have
grupos vulnerables
demonstrated
dentro del
a
sistema
commitment
judicial.
with vulnerable
Aunque aquí
communities
todavía no
within
hemos
the
establecido
justice system,
tribunales
even though we
especializados
have
para
not
tratar temas como
is
la violencia
implemented
doméstica, por ejemplo,
tribunals or
la
courts that deal
protección
with domestic
infantil, por
violence
ejemplo, sí
or
se han tomado medidas
child
en los
protective services
tribunales del sector
and the like,
público
but we
para
have
que los
taken
tribunales
measures
puedan
within
brindar un entorno
the
seguro
justice
y
system so that
actual,
the courts can
incluso
provide
en términos
a
logísticos,
context that
tecnología
is
e
safe
infraestructura,
and of
promoviendo
support
enfoques
with
centrados
a
en la
framework
justicia
that is
y
safe
facilitando el
and
acceso de
focus
la
on victims
justicia a
and
aquellos que
securing access to
tradicionalmente,
victims,
muchos países,
especially
incluso
those
nuestros,
who
han
traditionally in many
sido
countries like
marginados
ours
por
have been
vulnerables.
marginalized or
Verdaderamente
discriminated
falta
against.
mucho por hacer, pero por
There's a
supuesto
lot
que
that
hemos avanzado.
has to be done, but this is a
También
beginning.
reconociendo la importancia
Also,
de
we
la
acknowledge the
participación
importance of
comunitaria. La
community
República Dominicana
participation.
ha fomentado
Dominican Republic
iniciativas,
has also
documentos y
fostered
comunicación
initiatives
activa y
that
colaboración entre los
promote
ciudadanos
active
y el sistema de
participation from the
justicia,
citizens
incluyendo
and
talleres,
between the
campañas de
citizens
concienciación.
and the judicial
También, como
system
mencioné antes, programas
by
como
way
la
of
Carta
consultative
Comunitaria de Justicia
councils.
promueven la participación y el
So these
compromiso
projects
participativo
promote
en
the
procesos
participation
judiciales.
of the
Estos
and the
iniciativas
engagement of
también
the
concilian,
communities.
aumentan la
These initiatives
conciencia sobre los
facilitate dialogue
derechos legales
mm,
y empoderan
and
a las
foster
personas a
awareness
que se
about the
conviertan en
judicial system
participantes
and allow
activos
people to
en la
become
administración de
active
justicia,
participants in the
fortaleciendo la
administration of
cooperación
justice,
entre las
strengthening the
comunidades y el
relationship
sistema
between
de justicia.
communities and the judicial
En
system.
conclusión, el compromiso de la
Um,
De
to,
la República
to
Dominicana
end,
con la justicia centrada
Dominican
en las
Republic
personas está latente
commitment
a través de las
between the
iniciativas
um,
destinadas a mejorar
judicial
el
system
proceso
and its
judicializado.
people, it's
El apoyo
evident
y la
because of
calidad
all
de
of this
estas
we've mentioned.
acciones en Estados
In
Unidos
the
hemos
bilateral
observado como
summit of the
Países
democracy
Bajos,
with
etcétera. La República Dominicana se
Central Asian
comprometió a
countries like
fomentar la justicia
Kosovo and
centrada
other,
en la persona,
the United States
con
decided
participación del Poder
to
Judicial,
focus
la
and commit
Procuraduría General de la
to
República, la
people-centered
Defensa
justice,
Pública
to
y
defend
con también
to
el
public
apoyo de la
defense, and
ciudadanía.
also with the
Al
support of
priorizar
the
las
President
necesidades
of
de
the
las
Republic
personas,
and in
promover la justicia
prioritizing these
comunitaria
uh,
y
and
proteger a los
promoting
grupos
the
vulnerables, la
community engagement, the Dominican Republic has made strides to guarantee that justice is accessible, just and inclusive for all its citizens. These efforts uh, has the goal to strengthen the public trust and for strengthen the rule of law and a society that values the principles of justice and equality. This is just the beginning. There's a lot to be done, but we are sharing this, how we're seeing this interconnection of these concepts and some things that we've done here in the Dominican Republic. Thank you so much to all of you for your time and your attention. Have a good afternoon, and I am ready to take your questions later on if there is an opportunity for that. Thank you, Lisette, the principal advisor of citizenship. And so next, and without further ado, we are going to open the forum for the panelists that have come. We remember that we are launching the report on the independence of justice operators in the Americas, the regional situations and democratic defense, prepared by the Justice Studies Center of the Americas. Please, I would like to Ursula Oida Coitano, our panelist. We invite her to the panel, and and we also give the word to Patricia Perez, who will begin the panel.
Patricia está conectada online.
Por favor. Patricia, are you connected?
Si nos confirman, por favor, si está Patricia en línea.
Is Patricia online? Hay algunas. Okay, estamos. Please excuse the technical difficulties. We're just solving those technical issues for a few moments. I am not able. I am not able to. Okay. Okay. Now I am. First of all, I want to greet all of you who are with us today, virtually or in person, and of course, to bring cordial greetings to my ex-colleague from the board, the executive board at CEJA, at JSCA, Natalie. She was an executive for Ambassador Frank Morat, who we heard earlier. And also greetings to Cata Salazar, one of the directors, and I also wanted to mention my colleague and friend, Ian Murphy, who has also collaborated in these efforts. I would like to congratulate this initiative to present this conjointly on the side of JSCA. It's dear to my heart as having been part of the executive board. And also, I want to express that this report that we're presenting today, it is a really comprehensive report, and that Natalie Ponce and team got together. I am going to make some remarks, brief remarks, especially regarding standards that Natalie already mentioned. We are going to the next slide, please. As Cecilia Medina Quiroga has said, she's a judge of the Inter-American Court, and the due process of law is a cornerstone of the human rights protection system, the guarantee of all human rights, and a sine qua non requirement for the existence of a rule of law. Precisely, springing from this, I observed in this report that as the report mentions, there's an idea that Natalie already mentioned that shows that our continent is facing a complex situation today in regards of the, in terms of its democracy and the justice operators, especially the role of judges and prosecutors, also public defenders. As it was mentioned, this is less developed aspect, but all of these bring consequences. And for example, the report summarizes some risks and effects on democracy. For example, these approaches, populist approaches, and the bent towards authoritarianism. And this makes our institutions more fragile, including the tribunals, the courts, and they will be exposed in greater or lesser degree uh, from political powers or economic powers or criminal powers that exist in our region. All of this obviously happens uh, that limits the access to justice, especially from people who are vulnerable, and it has an impact on the level of trust and legitimacy on the democracy. In terms of this is strictly related to the work that the tribunal, that this judicial system has. And it has the first, as a first goal, it has to protect the human rights in the region. The courts have played a fundamental role in instrumental role in democracy in our continent, and it has contributed to strengthen the criminal justice and also democracy justice system. And also, it's crucial for the independence that our judicial institutions must have. The next slide. As we all know, Article 8 of the American Convention on Human Rights, it, it establishes as a need that every person, eh, so because of this article, as we all know, there are a set of standards that have been developed by the courts, and from such, we have articulated uh, the, uh, the due process, the legal due process, and this, it, as I have mentioned, in this context, it is important. It's relevant that we begin with a chapter that deals with that they elaborate the independence of the justice operators. And many of them are the fruit of the work of the courts themselves. And these elements have different dimensions, so they have to do with so we have to differentiate between internal independence and external independence. So, it, so this comes in hand. So the case of Arguelles et al. Versus Argentina in 2014 had to do with this issue. In this sense, the court has established that one of the main objectives of the separation of public powers is to guarantee the independence of judges. The objective of protection lies in preventing the judicial system in general and its members in particular from being subjected to possible undue restrictions in the exercise of their functions by bodies outside the judiciary. In this way, the judicial independence is derived from guarantees such as an adequate appointment process, the removability of office, and guarantees against external pressures. In turn, the court has pointed out that out all of this is in paragraph 67, 147. The court has pointed out that the autonomous exercise of judicial function must be guaranteed by the state, both in its institutional aspect, that is in relation to the judiciary as a system, as well as in connection with its individual aspect, that is in relation to the specific judge. Also, another element, an important element that the report presents, and it refers to certain dimensions that are civilized uh, uh, and have to do with academic work or scholarship. And it's undeniable that, especially because of the situation that the region is living through, and and also because of this emphasis on the focus on the juror and the facto, and the jury has to do with the normative aspects of law, but the but the fact is the way these attacks happen against the independence of the judicial system. An interesting case, Martinez Esquivia versus Colombia, in which the court mentioned that the court has referred, it mentions that the court has referred on several occasions to the need for states to guarantee an independent and objective investigation of human rights violations. In general, in the criminal spheres, has emphasized that the authorities in charge of the investigation must enjoy de jure and de facto independence, which requires not only hierarchical or institutional independence, but also real independence. Uh, this refers to this regularity that this report has for us. And I would like to refer to what chapter 2 mentions, and it um, has to do with the justice operators. And I think it's important that the report highlights the aspect of jurisprudence, or that that the court has by way of developing different standards, and the court should have such a high degree of independence that it allows to establish a concrete separation of the judiciary and the other powers. So in this sense, the court recently, uh, in the case in 2001, in this context of the Inter-American Council of Human Rights, this establishes that the separation of political powers or public powers so they in that case we avoid and avoid the influence, the external influence, but the court says that the separation of these political powers, it is a constant regulator of these political or powers. There should be harmony among the different organs, public organs, and the and there shouldn't be any interference among their companies. So the balance among powers is a result that has to be analyzed and has to be continually realized and reaffirmed through the political control of some organs over the tasks corresponding to others and the collaborative relationships between the different branches of government in the exercise of their competencies. So without any prejudice, and in this topic, I would like to highlight something that the report identifies as part of the current challenges, uh, and referring to the principles.
These principles are to be level. How to be in a specific point. To reflect in this
actividad que deben tener los Estados partes en materia de control de convencionalidad, justamente aterrizando estos estándares
like the constitutional control,
al contexto nacional, adecuando sus
there is a
ordenamientos,
context,
no solamente en materia
national
normativa,
context.
sino también a través de sus prácticas.
There is also the normative,
centrales del informe
internal normative.
concerniente a los riesgos y afectaciones de los operadores de la justicia de las Américas. En este contexto me parece
The concept of indefinite presidential
que el informe justamente aluda a las afectaciones concretas a la independencia a las
are
operadoras
also concrete things that
y que
occur.
precisamente la Corte Interamericana ha venido tratando y desarrollando en el marco de su jurisprudencia contenciosa. En este sentido, quisiera destacar lo que se menciona en el informe y que se refiere a que muchos de estos problemas van más allá de las
Many of these problems go beyond of the situations, external or internal situations mentioned before. The risks are not in this framework. The risks that are out of the report are those there was mentioned by the reporter of the United Nations about the like the organized international organized crime. But the inform refers to attacks in both ways, external and internal. Natalie has referred to it, but it refers not only about referring to the Supreme Courts and the comfort and the integration, and also from the legislative powers that actually goes that goes against that independence, but also internally, like the use and manipulation of the criminal law to sanction the judges, and they do not allow them to decide independently. Also, the others is situations that are happening in the country internally. And so they can allow judges to be persecuted criminally. This is another area of problem. And there are some standards that have been developed by the Inter-American Court. Next one. I will advance because the last problematic I would want to refer to the Rico case versus Argentina from 2019. It's about an impeachment. And it is about interference to the judicial power. The first one was
indicando que se trataba de una forma de control que ejerce el Poder Legislativo con respecto a los funcionarios superiores, tanto del Poder Ejecutivo como de otros órganos estatales, cuya finalidad no es otra que someter a funcionarios y funcionarios de alta jerarquía a examen y decisión sobre sus actuaciones por parte de la representación del Poder Popular. La siguiente, por favor.
Next one, please.
Y señala ahí la Corte que a pesar de lo anterior,
The court
en esa jurisprudencia no encontró
says that
este mecanismo de remoción de jueces y juezas por
the removing of judges was not analyzed the circumstances, the factual circumstances, and this is important in the context, defended the Constitution in the warranties, and the court established that in these situations are not contrary to the Constitution, while they comply with Article 8 to protect the independence, the judicial independence. And the court said as well that the court did not establish a process according to the guarantees, but but it must be a system must be conformed that complies with these guarantees. Unlike in a more recent case, the case Ríos Ábalos versus Paraguay, it is necessary that the powers of the authorities involved in this processing and decision not to be exercised in a subjective manner or based in political discretion, since this could entail an arbitrary infringement of the function of the judicial authorities. Consistent with this, although the impeachment proceeding takes place in the sphere of bodies of a political nature, when it is brought against judicial authorities, the control exercised by those bodies, rather than being based on reasons of political relevance, opportunity, or convenience, must operate subject to legal criteria, in the sense that the proceedings and the final decision must deal with whether or not the imputed conduct has been accredited, observing the due process of law.
sino que persigue asegurar que dicho
with established standards of judicial conduct and through fair, objective, and impartial proceedings according to the Constitution of the law, this becomes imperative in as much as the free removal of judicial authorities fosters objective gaps as to the effective possibility they have for exercising functions without fear.
toca otros temas que
This touches other subjects that report identifies, for example, the stability of the provisionary appointments. Next, please.
En el sentido de que en este mismo caso
This same case,
se señala que existe
what,
una relación
in
directa
the case, there was a direct relationship between the institutional dimensions of judicial independence and the right of judges to access and remain in their positions under general conditions of equality. This is central for the independence because there should be an adequate process of appointment and stability and removability of the position, and in that way, these positions can be protected from. They are the final remarks. I am going to finish. So, the reflection, and I will be done in a minute. The guarantee of stability and removability is central for the independence of the justice system, and they have to guarantee it from the jurisprudence and the rulings. I don't have more time, but I want to congratulate the Justice Study Center for the Americas for advancing and putting together this report. There are other things that are positive in the matter. There are still challenges in the issue of the independence of justice operators, and this report is our own goal and advance our campaign and improving everything that's possible to maintain the independence of our legal operators. Thank you again.
Diana Oroku is the president of the Inter-American Council of Judges and prosecutors. I bring you greetings on the name of the Inter-American Association of Judges and Lawyers. We want to greet those who are on the panel and on this main table, those who are listening to us. This report, when I began reading it, I was thankful for your taking the time to develop a technical report that would verify the conditions about what we consider what it is judicial independence, but what it is not, and what are the new critics or that fall on us. I will not deal with what you have already mentioned, but I will give updates on internal or external influence, the jure or de facto leanings. But I want to deal with what are the conditions that, according to the report, regarding how we live on a daily, how the judicial systems in Latin America validate the findings of these findings. The findings were to be expected. We are in a decline, a deterioration of the democratic conditions, and for the exercising of the judicial roles for judges and prosecutors and public defenders. And there is a evolution of democratic processes that is palpable. And this is not only causing democratic instability, but a decline, an institutional decline that is against the judiciary. And there are in some cases, these issues already have materialized, and due to this, impunity has increased and corruption has increased, and and the effectiveness that the institutionality is supposed to promote, that power has been diminished. Uh, we have been able to see from some time ago within the judicial systems in Latin America, we have visited continuously in cases like Guatemala and Central America. We know the conditions in Honduras and El Salvador, but in Guatemala, there is a situation that is increasing in the decline of the conditions that support an independent judiciary. Last week, because of conditions of safety, we were not able to visit. These are conditions that uh, the JSCA reaffirms, the report reaffirms that there is a structure, a technical structure that we can see regarding what we see on a daily basis in terms of the deterioration of the independence of the judicial system and also the effect it has on the citizenship because there is the expectation of impartiality from judges, uh, but the deterioration of these impartial conditions makes it so hard that that justice to be uh, uh, so the deterioration is basically organic within all the um, institutions in America Latina. We have seen that there is a narrative that is geared towards is pretty much copied and from the executive branch and the legislative branch and other powers, maybe the media or, um, that are that are having a relationship and are working against the judicial power to validate one of the findings of the report that these narratives are building spaces of legitimization of the judicial power, and these spaces are filled with structures or legislative conditions using those uh, preconditions so that the legislature and others that instead of strengthening the judicial independence by way of legitimacy or legitimate ways, it's on the contrary, it's deteriorating the influence of the judiciary. There is a, uh, a collaboration uh, in terms of this narrative that is that has as a goal to subvert the legitimacy of the judiciary and wants to self-serve of that narrative to assume more powers. And one of the needed conditions that we have or we need is that the report establishes is that every day we become even more independent in our region in terms of the judicial system. And that's what the report calls about blind spots. Those are the points that the report mentions and validates, and these are analyzed in detail. I'm going to mention for the diminishing of the conditions for the independent exercise of the judiciary and the institutional power in all of the judicial powers. And I'm going to classify that the same report makes. And in the report, there are some criteria, democratic criteria, full democracy, democracies that have fault, and then authoritative or authoritarian democracies. The process is so important that it is classified in the report that Costa Rica, Uruguay, and Chile are full democracies according to the report, and two of these countries in the month of March there is the hearing that happened seeking intervention because of the um, independence deficit that exists. While it has to do, or if it has to do with lack of appointments, like in the Uruguay case, that they have a framework or structure of judicial careers that do not correspond with no standard, international standard for international careers. There is no objective process for appointing. So there is a huge discretion, and that creates some imbalance in the judiciary. In Costa Rica, full democracy also, it is mentioned in the report, and it is mentioned with exceptions. And Ms. Natalie mentioned at the beginning that we have the best democratic index, but the lowest index of judicial independence, because there has been a series of legal structure or judicial structures that have been fomented from the executive and legislative powers, including in, some of support from the Constitutional Assembly. Uh, and this uh, constitutional deterioration has increased by 200% in the few years. It was 200% of resignations from justice operators in the last few years, and we need to see this. We have to take this into account so that we can have the warnings, the early warnings, but we also need to foresee and be proactive so that we can deal with these situations and improve them. Another topic that the report broaches is it is a safety standard that is not validated in an efficient way in all our countries. Is uh, the the situation that allows judges and prosecutors to act as with huge powers to the threats that they suffer in the exercise of the roles as prosecutors. Are in particular, it is evident that there. Uh, I- in the Latin American Federation of Magistrates, we've seen this topic with great alarm, because in Ecuador, many judges have been threatened. We know what has happened in Paraguay and in Guatemala, and because of the exiles, because of lack of safety. And the topic is that there are standards, but the implementation of these standards in concrete is not working in these states. So to guarantee the judicial independence, and in addition, the instrumentalization, as Ms. Patricia has mentioned, that the criminal system has, uh, uh, I repeat again, in Guatemala's example, we received a report through the FLAP and the International Association of Magistrates. Also in Bolivia, a judge was criminalized. He hadn't even finished signing a protection order, and he was put in handcuffs and taken away. And we have seen a series of examples, concrete examples that demand that these conditions may be improved in Argentina, in Peru. So another criteria that has to do with cases of uh, provision, and has to do with the judiciary and the in since March, there are judges that are resigning or transferring in Honduras to other jurisdiction, and the Inter-American Commission on Human Rights have touched on this subject. But the the provisionality in Bolivia, that there are 487 judges, 47 of the judges, staff judges in Bolivia, went from a transitory or temporary situation without any objective process to have them replaced. And to finish, the international standards have to be rethought, because as the report mentions, there are robust standards, international standards, but we need many standards for prosecutors and also for public defenders. But we need to rethink and revalidate these international standards, because there may be things that are being left behind as these key points. And as the narrative says, that is intentional. So we need to verify them, to be proactive in and allows the possibility to act rapidly or quickly alongside international mechanisms that can help us. I still have many things to share, but this is a topic that we cannot deal with in 10 minutes, but but from organizations and in that but from our organizations in a responsible way we'll continue, and I feel very proud and with the last slide that Natalie presented, and we have on the agenda to make several proactive exercises that not just with the JSCA, but with other organizations that are committed with the topic of justice and the due process that we deal with. Thank you for your attention. Gracias, Adriana, the president of the Inter-American Association of Judges. And now we go to Ms. Jorge. You have 10 minutes. Thank you. 3 minutos.
Hola, buenas tardes. No sé si me escuchan bien.
Hello, good afternoon. I don't know if you can hear me okay. We
No pueden ver el vídeo, eso sí. Me dice que el anfitrión lo ha parado.
we can. There's an issue with camera.
¿Ahora sí puede?
Sí, perfecto.
Okay.
Bueno, en primer lugar, me gustaría
First, I want to thank the JSCA and the organization who has invited us, especially me as the coordinator of the JAM, and we follow the activities of the public ministries. And in this report presentation, it is a comprehensive report. It is critical, and in terms of public ministries or agencies that I deal with as the coordinator with the Inter-American Association, as the report establishes, it's something that is forgotten. There aren't any standards, and when we talk about independence or autonomy, we have focused on the part of judicial autonomy and the aspect of the prosecution. The independence of the prosecutors have been left aside, and we need to analyze the situation. We need to establish parallels with the situation. We have to make a parallel. When we make a parallel with the situation of judges, as the report establishes, we're heading towards a system that is that indicts and that signals to a deterioration of the criminal justice system. And this is not just something that has to do with the international community, but the Inter-American Association of Public Ministries is concerned about this. But 2 years ago, for example, or less than 2 years ago, this group was created, and all of the advances that were they are far from being consolidated and from standardized, but our current reality, practical reality, is that we find ourselves being continually attacked. The autonomy and the institution of the public ministries as institutions, but also and particularly attacks against the independence of the same prosecutors. And this is validated by the report that is being presented today in all of the Americas. So it is being validated with the Inter-American Association of Public Ministries. This is a situation that includes ministries like mine in Andorra, and same thing in Portugal, and in Iberia. It's not different. It's not just Latin America, but the attacks towards the public ministries and its members are really raw. And particularly when we touch on studies that have to do with corruption.
The infiltration of criminal agents in the institutions, other branches, different to the public prosecutor's office. We cannot allow that they can be dominated by branches. That is very important. In the international trend is accusatory system. We have to include the judges and the prosecutors and even the public defenders to guarantee their independence, and not only about security issues like murders that have been happening, as one of our speakers said, but also the security of the public prosecutors and what's happening in the structure of the prosecutor's office internally, and the appointment of the public prosecutors. There is no trust in the public prosecutor's office as a whole, as it has been said by one of the speakers. At the end, this independence and the only exercise needs of certain elements of autonomy in the organizational, budgetary, and the mechanisms that do not allow them to be legitimized. In Ibero-America, there are less resources to do their functions, and that are much lesser than the ones that have other branches of the government, like the ones that protect from corruption. That is what all these systems and all what the report includes are like basic fundamental for the public prosecutor's offices. We still do not have standards established from our point of view, and as the report mentions, there's a comparison between the independence of the judges and magistrates, the independence of the prosecutors, and at the end, they are not very different. Those that independence from a judge and a prosecutor, probably in the organizational structure, they may be different because the prosecutor needs to respect the therapy, also organizational system, but the fact that one person decide, for example, a higher prosecutor that can decide on another prosecutor's action, it is very different from what happens with the judge to obey the ruling of a higher judge. There are nuances, but we have to secure the protection of the prosecutor in the structure of even of the public prosecutor's offices. For instance, providing a prosecutor of the resources of the tools that a prosecutor needs to do his research. This analysis that of the balance that exists between the independence of the judicial independence and the prosecutors independence. In our own research, in other countries in Europe, we have looked at some of the human rights of the EU. There is a ruling of Covesi versus Romania, in which one of the prosecutors was removed from office, and that research says that the independence of prosecutors is an independent requirement. That independent justice will we have if the principle of accusatory principle, the only one that the prosecutor considers, and the thing is already decided, and it's not only that. It does not respect that the independence of the prosecutor's
provenientes
role,
de deseos o designios políticos, etcétera.
what comes from decision, political decisions, and the only way in which the global justice could be independent
Sí, por supuesto, una justicia independiente es garantizando que
and
también
independent justice
los
guarantee
fiscales son independientes. Por tanto,
that
enhorabuena por el
the
informe,
prosecutor office is
enhorabuena
also
por hacer
independent.
referencia también a la
So thank
independencia de
you
los fiscales,
for
por poner
referring
este
to the
tema
prosecutor's
en la
independence
agenda y por destacar
and
que
for
tenemos que
including
trabajar todos
the
hacia la
subject
estandarización
to have a
de unos
standardized
criterios claros sobre qué consideramos
criteria that are
independencia
important for
de
the
la fiscalía,
independence of
justicia,
the
personal, etcétera,
prosecutor's offices.
y entre todos ir dando pasos para la estandarización
And
de este tema tan
to
importante
continue
como es la independencia, ya no solamente
making steps
de
to the
jueces en el Estado,
standardization
sino también
to
de
have all
juzgados.
these
En cualquier caso,
situations, all these
muchísimas gracias por habernos dado voz
standardized.
en
Thank you for giving us a voice
este acto y enhorabuena por el informe.
and best luck for that. Thank you, Mr. Borja, is the coordinator of the working group of autonomy and independence of the prosecutor's office, CEJAoficial. Now we have Ursula Bendache, the Director of Independence, Judicial Independence of DPLF. I want to congratulate JFA for this report because it emphasizes the many sciences of different countries and regional and some of the challenges and the threats to the judicial independence in the region and includes the deterioration of democracy. And I want to emphasize the part of the report that the independence of the judiciary is not possible if there is not more democratization in the other powers of the government. And I commemorate that we can work with other organizations like the American organization. And I want to close. I want to highlight the first one is the role of corruption and the penetration of the organized crime that characterizes the most serious situations in the region. We have to address it from a perspective of human rights and corruption, especially those in systems where are more vulnerable to that influence. And I want to suggest that these causes and it can be also seen from a gender view, because the impacts of judicial independence is not the same if the judges or the the justice operators are females or males. There are other minorities that minorities should be also in the justice field. We are promoting that, and we think that that there's space in this agenda and this roadmap to include this perspective. And I want to also say that the report systematizes a very ample scope about human rights, and these have been studied by the court, by this organization, by the rapporteur, the United Nations rapporteur of the Committee of Human Rights, and the one for judges and magistrates. But there is something else that is complementary. For example, the international conventions on corruption that address the other side of the coin, which is very important. Otherwise, they become like islands, and they become actors in a corrupted ecosystem. And this other perspective has to be present as well. We celebrate this report the challenges and roadmap that has been shared for the civil society. We work in this of independence, and we are very happy and we can also input in what could be good. Thank you and congratulations. As of Justice for the Americas, we are ending the launching of the report, and we are grateful for this, for our host. And thank you for our audience in YouTube, and thank you for the videos that are present. Thank you. It was so much.